Welcome to today's webinar from the Legal 500 in association with FRIES, called Strategies for International Litigation Risk Management. But obviously you already knew that, otherwise you wouldn't be here. I'm David Burgess. I'm the Publishing Director of the Legal 500, and I'm here to briefly introduce our panel. But obviously they're going to tell you much more about themselves as they start speaking. Just a couple of housekeeping points. The webinar is being recorded, so if you do have to step away, you'll be able to catch it later on when we put it up at legal500.com, and we'll email everybody with the information. Also, with all our webinars, we do like them to be interactive as possible. So we are aiming to have a Q&A at the end of the webinar, but don't hold your questions until the end. If there's a burning issue that you really want to know about, do use the Q&A function or the chat function if you need to. Send in the questions and we'll see if we can answer them along the way. Okay, so time to get straight into this webinar. I'd like to introduce our panel. Chairing our session today is James Hartley. James is the partner and national head of dispute resolution at FRIES. And joining us in our in-house panel are Beatrice Nelson-Beer, Chief Legal Officer, Global Head of Legal, Regulatory Affairs, Compliance and Human Resources at PM International in Luxembourg, and owner of the longest job title in history. We also have Nick Moore, Director of M&A Transaction Solutions Team at Aon here in the UK, and Nikhil Patel, Chief Legal Officer and Global Antitrust Counsel of Upfield in the Netherlands. And with no further ado, James, it's over to you.
Thank you, David, for that introduction, and thanks again to our panel members who we'll be speaking to in a moment. Before then, I just thought it'd be useful just to set the scene, if I may, by setting out a few trends that we are seeing or that are reported in global litigation, cross-border litigation. So I'll rattle through those, and hopefully they will sort of trigger some thoughts in people's minds as well. Increased corporate social awareness, CSR, ESG. I don't think there'll be any surprise amongst most people, but that is playing in two ways. Partly it is becoming a cause of disputes, a cause of litigation. So as more robust ESG standards are being imposed in various jurisdictions, that in turn we're beginning to see that passed on through, for example, supply chains, ESG clauses, which are a fairly new concept. So the whole ESG piece, as I say, can and is becoming the cause of some disputes. Equally importantly, though, is the way in which corporates are responding to disputes and having a very well-developed now sense of corporate social awareness, and that again plays into the way in which corporates respond to disputes and respond to litigation. Doing the right thing is an increasing theme that we are seeing even in pretty viciously fought litigation. You know, corporates see the value that can be created in responding appropriately. That's the first theme. The second theme, the emergence of what we call the business of litigation, which we are seeing more and more, and it's here to stay. And that's a combination of, on the claimant side, investments by law firms, by corporate claimants themselves, by litigation funders into litigation, seeing them as investments, seeing them as projects that don't necessarily need to be a cost, but can in fact add to the bottom line. And liquidity management links into the business of litigation and capital allocation, things of issues of that type. We'll come on to talking about that in a little bit more detail in a moment. The third theme, increase in class action litigation in many jurisdictions. The different drivers for that. In certain jurisdictions, there's more activity than in others. So, for example, in the UK, we're seeing a lot of competition-related litigation, collective proceeding orders being made with increasing frequency within the Competition Appeal Tribunal. That's just one example. As I say, there are several drivers: increasing litigation funding availability, cross-jurisdictional, is driving class action activity. Increasing consumer protection regulation and statutory provisions in various jurisdictions, again including the UK but elsewhere, is fueling consumer-based litigation of a class action nature. The technology and social media is obviously assisting mass collaboration between potential claimants, which again leads to litigation groups being assembled. Another theme, more sophisticated litigation risk transfer solutions, which are being adopted by corporates. I mentioned liquidity management, capital allocation. So corporates and organizations are getting clever now in terms of the various solutions that can be deployed to either hedge financial risk, transfer financial risk, or manage litigation risk in the more traditional ways and the more procedural ways, such as mediation and remote mediation, remote ADR is increasing year on year, which is also driven by the digital transformation that we are all seeing, which impacts both procedure and also the types of disputes we are seeing as well. So digital transformation, no surprise, is a continued trend and a continued driver. And finally, international arbitration as a means by which disputes are resolved is still on the increase. So year on year, the arbitration organisations report increasing figures, not only in relation to the number of disputes handled, but also in many cases the value of the dispute. So the amounts in dispute tend to be getting larger in the arbitration world. So there are a number of reasons why arbitration is increasingly attractive cross-border. And hence it is on the increase. So those are some themes. There are others, but they are the ones we are seeing increasingly. So leading on then, moving on from that into our panel members and having a discussion with Nick first of all. Nick, I've just been talking about the business of litigation, as we've called it, and risk transfer solutions, liquidity management. What are you seeing in your business in terms of the sorts of solutions that are being adopted?
Thanks, James, and thanks for having me on. So I think probably the first thing is perhaps there isn't the mainstream understanding of what litigation risk insurance is, but essentially what we do here at Aon is to find creative ways to deploy insurance capital into all different kinds of litigation situations. And this sort of insurance is being purchased by defendants, claimants, law firms, and investors into litigation-related assets. The policies we place are bespoke, customized for the client, and whatever it is that's motivating them to get the insurance, whatever risk they're trying to eliminate or minimize, and whatever opportunity they're trying to take advantage of. So we have a great degree of flexibility in the sort of coverage we can provide, precisely how that coverage is structured. There are a couple of core solutions that we can maybe talk about now. The first being adverse judgment, or what's called AJI insurance. This is probably the most straightforward explanation of what litigation risk insurance is. So say you are acting for a company that's a defendant facing a damages claim of, say, £100 million, and a private equity purchaser is buying your client but does not want to take on £100 million litigation exposure that will crystallise potentially years down the line. That PE firm might insist on £100 million escrow or an indemnity that might not be palatable to your client, particularly if your advice is that the litigation is without merit, or that the claimants are dramatically overreaching in their damages ask. And the way that conversation usually plays out is that your client will tell the PE buyer that litigation won't result in a finding of liability, but even if it does, the damages won't exceed, say, £10 million. And so they offer to escrow 10 million, not 100, that the claimants are asking for. But that representation is probably going to be quite cold comfort for the PE buyer, because they're at an informational disadvantage to your client, who may have been living with that litigation or the threat of that litigation for months or even years. So the buyer will usually stand firm and insist on that 100 million escrow. And what we can do that in that scenario is, if we can demonstrate that this is worth a 10 million, not £100 million claim, we can put in place a £90 million adverse judgment policy with a 10 million deductible, and then the deal can close with a 10 million escrow rather than 100 million escrow. So ultimately, if years down the line there's a 50 or 100 million judgment in the case, the insurers in that policy are going to be responsible for paying any damages beyond the deductible. So that's one example on the defence side, but the takeaway for that risk transfer solution is that it involves litigation that is unlikely and demonstrably so to result in liability or significant damages, but the prospective defendant, through no fault of their own, or for that matter, the lawyers just can't get rid of the case right now because winning a trial or appeal will take years. But the threat of that damages award in the litigation is preventing the client from doing what they want to do. So we can come in and ring fence those exposures, and that allows the defendant to get on with their business. So that's quite an interesting solution on the defence side. Where we're seeing a lot of demand currently is in the claimant side in what's called judgment preservation or JPI insurance. And so using the same numbers, you're acting for a claimant who's won a damages award of £100 million. Everyone's celebrating, high fives, the judgment's been handed down, but no one's seeing any money for years until the case has made its way through either the post-trial motions in the US, if it's US, or the appellate process here in the UK. And those processes could see a judgment reversed or significantly reduced. And with a JPI solution, the prevailing claimant can now lock in value. So say you put a £75 million JPI policy with a £25 million deductible on your £100 million judgment. If that judgment gets wiped out on appeal, the insurance will pay £75 million. Or if that judgment gets halved on appeal to £50 million, the insurance will pay 25, not the full 50 because of this 25 million deductible. So that's a really useful tool for locking in value. But just to touch on your point about litigation funding and legal assets and monetization, this is also a way to monetize judgments in extremely cost-effective terms. So if there's no real collection risk associated with that judgment because the defendant has assets, multiple assets that are within the jurisdictional reach of the court, then once you have a JPI policy in place, you've effectively turned a contingent asset into a guaranteed one. So the plaintiff now knows it's going to end up with £75 million in this example, no matter what. If the judgment is affirmed, they get 100 from the defendant. If the judgment is zeroed, then they get 75 from the insurers. And if it's reduced to, say, 25, they'll get 25 from the defendant and 50 from the insurance policy. And so because the appellate risk in JPI is now capped, the claimant's now only facing durational risk, still an open question about when the case will finish. But there is certainty that the damages recovery, the payment, that will be paid either between the defendant or the insurer or a combination of both. And in that insured scenario, interestingly, a client can then go and raise capital against that insured judgment. And that's very interesting now from a liquidity perspective in businesses where we're treating these litigation awards or arbitration awards as legal assets. So conscious of time, I've a couple more things just to touch on briefly. What we're also seeing, principal protection for funders and law firms on both single case and a portfolio basis. In the portfolio context, that essentially means wrapping a collection of uncorrelated litigation investments for funders or contingency fees for law firms with an insurance policy, which basically says if these cases don't produce X pounds in investment returns or contingency fees, the policy will true the funder or the law firm up to X pounds in coverage. And then, of course, ATE insurance, where the policy will allow claimants to cover their own costs and disbursements, and in cost-shifting jurisdictions, the costs will go aside, and that allows them to approach a case or go to trial without being intimidated by the threat of the cost at stake if the case is lost. So that's a whistle-stop tour of some of the things we're saying. Back to you.
Yeah, thanks, Nick. I mean, that is highly specialised stuff, and it always reminds me of why we come to you guys for things like this, because it is seriously specialised. But I mean, the sorts of risk transfer solutions, or some of the ones that you're talking about, some of those are back end of the process, aren't they, when there's a judgment in place? But these, of course, are part of the wider spectrum, sort of cradle to grave risk transfer solutions. Some of which can be much earlier on, can't they, in terms of adverse cost insurance and funding and that type of thing?
Absolutely.
Yeah, great, thank you. Turning, if I may, to you, Nikhil, a sort of general more generalized question about how you are seeing the litigation risk landscape in your business, and whether you think the environment has changed for the worse in terms of more risk, and what are the principal concerns that you've got from a litigation perspective within the business?
Thank you for having me, everybody. So I tend to agree with you in terms of what you said about ESG. I think, the term CSR is kind of somewhere along the way morphed into this broader term on environmental, social, and governance that we've kind of started to take more cognizance of, not just from companies' perspectives, but also from PE firms and other potential investors who now more closely scrutinize what your ESG agenda is before looking to make investments. And I think the key reason for that is, as you suggested, the increased amount of litigation surrounding the ESG agenda that you kind of create for yourself, right? And doing the right thing, as you suggested, was also one of the main things that people are starting to look at now. It's not just how much you try and put back into the society that you immediately affect, but rather almost the corporate values and the policies and agendas that you ascribe to, and how closely you're able to follow that. So keeping that in mind, and the fact that it's become a significantly more complicated environment to sort of work in as a company, I think that the risk is that with so many moving parts, especially as a large multinational, it's hard to keep everyone on the same track and to say that, look, these are global standards that we will adopt in whether or not local legislation covers the same thing. And to a large degree, I think the ESG agenda doesn't really fall into local legislation in any case, because it tends to focus more on what is it that you're doing that affects the people of society around you outside of what the law says is right or wrong. And it's more a moral and conscientious approach. And the minute you bring in that subjectivity, you're looking more local, because morals and, obviously situations are subjective to the sort of environment that they're in, which tends to be more local. And while at the same time creating global policies to govern that. So I guess the first thing that I'm kind of worried about as a large multinational is, how do you make global policies effective on a local scale and take local cultural difficulties and ESG norms into consideration when you're still making decisions from, for example, a mothership in the Netherlands, right? And that, for me, is something that companies have both done really well and failed at. A good example of this is, for example, Amazon in South Africa, where just building a new office and investing in Cape Town, something that would have been seen as a positive, just a couple of years ago, is now shrouded in controversy because of their failure to engage with local communities that lived around the area, and without realizing that the land that was being built upon had certain issues that were, sort of associated with those communities. I also think that, to an extent, social media has a large part to play in creating this increased litigative environment that we're currently living in. The speed at which problems can now be circulated and the impact that can therefore be felt on global companies as a result of that means that it's a new world, right? It's the digital transformation that you were talking about, but not necessarily on the dispute resolution side, but more on what I'm going to call the dispute creation side, if I may. Simply because you earlier, if you had something that happened to you, in Nairobi, it was a Nairobi issue. But now, with ESG being involved and the moral policing and all good things to a large degree as well that are in place, it's no longer a Nairobi issue, it's a company issue. Right. And I think that for us is something that we're still coming to terms with from the legal perspective on how do we create policies to deal with this. I mean, traditional crisis management and, litigation management doesn't deal with the speed and scope of these issues, and also doesn't necessarily deal with the butterfly effect and the knockdown effect that having one issue somewhere causes. Because regulators abroad suddenly see this on Twitter and start to pick it up and say, if they did it there, they're probably doing it here too. And so I think that's primarily where I'm coming from.
Yeah, it's so interesting. And the sort of speed of reactions across social media is, as you say, a very real issue. I mean, the fairly recent publicity around the P&O ferry company employment steps that they took was an example of that. So on the one hand, the company may well have believed it was acting within the employment laws, with whichever jurisdiction it was, but that didn't matter as far as the media and doing the right thing was concerned. Everybody felt they were not doing the right thing. Classic example. So, and what we find when we're talking to our corporate clients on the sort of dispute advisory piece is that in virtually every scenario, we're not just talking about the technical legal analysis, we are talking about the reputational aspects, and importantly, talking about value creation. So in any given situation for a corporate, for all the reasons you were talking about, Nikhil, the way the company comes out of a dispute or a regulatory situation can very often create value for itself and for external stakeholders. And that sounds counterintuitive when one's in the thick of a nasty situation. But if the whole lessons learned thing is adopted and action happens within sort of structured framework within corporates, then improvements come and value is created. So it's sometimes it's difficult for corporates to see it, but certainly increasingly we are seeing that value creation piece very high up on the agenda for all the reasons that you touched on. Beatrice, if we can ask you to chat to us, if you would, about how you are seeing the sort of response regime within your company and others. In other words, what can be done by corporates to, first of all, minimize the risk of litigation, and then when issues start to emerge, actually steering it in a positive direction? What sort of things are you seeing?
I think the key thing is here, what actually counts is the early involvement of the in-house legal team. That always comes back to the same crucial aspect. So what you know you can deal with, what you don't know, well, we all know how it ends. So to mitigate risks here, I see it as a major job as the GC to make sure that their team is actually educated on the actual targets and also on the challenges of the business, because otherwise we can't understand, we can't provide the help. So one big thing is to basically train the team up for risk awareness on the certain issues. In every business, there is certain areas where you are potentially at risk, either in a specific region, all over the world. I mean, we're dealing on 5 continents and we are facing various challenges from all over, from employment cases to corporate cases to competition cases, from food law to marketing law. So we have a little bit of everything here in the international headquarters. But what we have discovered is the earlier we engage with our stakeholders, the better. So part of my concept here with my team is based to encourage them to constantly manage our stakeholders, to network with them, to deal with them as close as possible, to educate them, as I said, what is the business purpose, what we're aiming for, because at the end of the day, we are part of the entire performance of the company. The legal team can't exclude themselves saying, hey, we said so. No, I mean, we're all contributing to the overall success of the business. So this is how GC and their team should see themselves. We're a support function, a service provider, and at the same time, a valuable part of the business. So that is basically one major thing. So, and having these trustworthy relationships with your stakeholders within the business has proven me along my career and the various companies I worked for very rightly here, because I mean, picking out British Gas, who I worked on 3 different sites each week, basically, sitting with my stakeholders, but it has proven success. So I knew what their issues were, I could understand them, I had the trust of them that it came to me at the early stage before it actually reached that stage where it comes to potential litigation cases. So therefore, I think that's the 2 major parts. Yeah, that count.
And Beatrice, do you find that when there has been a piece of litigation of one kind or another, that you find ways of looking at why it happened in the first place? And in some situations, there's nothing that could have been done. There's certain things that we should be on the control of the corporate, but there are other things that there may have been things that could be tightened up within the company. Are you finding that you're able to persuade the business to follow through on changes, implement changes from lessons learned? And how do you
Yes.
how do you get the best results from doing that?
We always do a lessons learned. We had a few really big cases, I'm not naming particular ones, but we always do a lesson learned afterwards and see what could have been done better here. What are the things we should implement on the back of that? And also, what do we learn from this particular jurisdiction? Because Nikhil said it already, not every jurisdiction fits under the same umbrella. We all have our corporate policies, we apply our procedures, what we normally do, but it just simply doesn't work in each country or continent. So yeah, as I said, the lessons learned we always do, but also we consider that things like this will not get repeated as we involve a few more departments to actually provide trainings to our stakeholders within the business to basically create an awareness that it doesn't come to that in the next, yeah.
Okay. So just moving on to, again, a form of dispute risk management, litigation risk management, which is mediation, and particularly remote mediation. Just interested to hear any experiences, either from Nikhil, Beatrice, or Nick, in relation to whether you have yourself been involved in any remote mediations, whether you see that there's a place for that. Obviously, with cross-border litigation in particular, there can be scope for it. Have you had any experience, or have you had any views on whether it has a place?
Well, my kind of limited experience, I left private practice kind of 10 years ago now, but have worked before joining Aon in the litigation and finance sector, where of course time is money. And during COVID, there was initial kind of perhaps fear that because of the pandemic, mediations, court processes wouldn't happen because we could never get anyone in the same room. And of course, that can drive down IRRs and returns in cases which ultimately might be successful, but to an investor winning after 5 years is a different story from winning after 6 or 7. And so we were very enthusiastic in the end about seeing how all this could be brought online, and mediation, arbitration being done remotely, and often to great effect. So that was my limited experience, but certainly on the investment side, it was welcomed.
Yeah.
I have to say, I mean, in terms of the effectiveness of digital meetings as a whole, I mean, both for dispute resolution as well as for contract negotiations, large-scale joint ventures. I mean, COVID didn't really stop too much, business from happening, in terms of people still needed to talk to one another when they were negotiating contracts and setting up business deals. I was quite surprised at how effective it's been. I mean, simply something like this webinar as well. A few years ago, this would have been a face-to-face conference in a hotel room with a view as nice as what Beatrice has in her background, right? So, I mean, I think we've all been pleasantly surprised with how effective online discussions have been. However, with the rider, that the place where I foresee and have had some difficulties, to be perfectly honest, is more in dealing with authority hearings, especially in developing countries, which is primarily the areas that I look after. You struggle with call dropouts, inefficient use of technology in terms of, can you actually see the person on the other side? And generally, it makes it a little bit more difficult, particularly when you're dealing with authorities that, have a great deal of power and are standing there, and you're trying your best to kind of explain yourself to them. I find that it's much more effective to do those in person.
Yeah, and I think as well, it depends on the nature of it. Does depend on the nature of the dispute and the dynamics, and whether there's a commercial relationship element to it. Because on the one hand, there are some disputes which are pretty much purely financial equations, zero-sum games, as it's known. And they quite often can be very effectively done by remote mediation. There are other disputes where there's a significant history to it, and there's a lot riding on trying to rebuild a corporate relationship, for example, when actually being in the same room is what's needed to sort of break down some barriers. So yeah, it's one of the modern day judgments that we all have to make, remote or not remote. But as as I think we've all said, we can all see the benefits of sort of digital way of doing things. which is but then there's a price to pay. And we touched earlier on about social media and some corporates being on the wrong end of some pretty significant group actions, which have been fueled by social media. Sometimes they're justified actions. In fact, often they're justified actions. Moving on to a different topic, if I may, but it's still on the risk management side of disputes, and that is funding, litigation funding. And that is of varying relevance depending on which jurisdiction one is in and what kind of litigation one is involved in. Interested in views, though, from an in-house perspective, Beatrice and or Nikhil, as to whether you see any part for funding in the sorts of litigation that your company is involved in, thinking clearly on the claimant side, where you have a claim as a corporate, whether there is a place for bringing external capital in or monetizing a claim. I have to say it's still got a long way to go from our experience in the UK in terms of corporates using it, but it is beginning to happen. It is more being deployed in group actions, but not just group actions on the claimant side. But interested in any experiences you're having or seeing of funding.
So we personally haven't had any experience with that yet, but I can clearly see that this is on the rising. So here, whatever came up on our plate, we had to fund ourselves so far. We're in the lucky position that we can. So as a company, but coming back to the point, you're going for litigation, funding litigation. The first step is always to actually judge, is it worth it? I mean, I've one case here on my desk, which takes place in Singapore. It's running for the last 10 years. It could have easily been resolved by ADR, but now it's a legal case over there. And we even had the virtual hearing for a week in a Singapore court. Basically, I was sitting there at 2:00 in the morning, listening to the court hearing, doing cross examinations with our lawyers there virtually. That was an experience that is, clearly by far not ideal, because you're missing out on the actual presence being in court. We all know what it's like. Having this virtually is a different story. But here I can say, in terms of funding such a thing, in the end, the whole legislation process costs us 5 times more than the actual claim. So, alternative dispute resolution is definitely the first thing we would always go for, instead of letting it come to any court cases. We always try to basically stop it right in the beginning, if possible, whatever it is. So that's up from my side.
Yeah.
I have to say, I'm on the same page as Beatrice on this. I mean, I think that, as she said earlier, early involvement of the legal team is key, right? And usually when that happens, the question asked is it really worth it? And more often than not, the answer is no. I have to say, as a food manufacturer, we're mostly used to being claimed against rather than being the person who's doing the claiming. And I'm sure Beatrice feels the same way. So for me, what I think sounded most attractive from this, but I have to be honest, my experience with it is basically zero, was the private equity hedging. I mean, we're private equity owned, and therefore automatically when you're looking at any potential exit and you have these large litigations on the case, I mean, it's nice that we mentioned class actions, because we've seen a couple of those, and automatically, as I mentioned earlier, before, anyone that's seen Erin Brockovich would see how difficult it is to get class action suits together. And now you have targeted Google and Facebook ads that say, do you want 500 euros? Click here. And have you bought an Upfield product in the last week? So, I mean, with that sort of availability of claimants, it becomes very difficult to take calls on, is it really worth it? So one of the wonders of working from home, right, which is that automatically digital is better. But anyway, so to my point, which was that, I mean, at the end of the day, when you're making these decisions on whether it's worth it or not, more often than not, as when you're looking at the number of claimants, you tend to say, look, settlement is key, or you go into an ADR resolution. However, I do recognize that when those systems fail and you're still looking at exiting as a company, you would want some sort of hedging procedure in place to ensure that you don't have to put millions into escrow. And I think that's something that could become really interesting.
Yeah, it's especially just to pick up on that point, especially when, as a company like yours, you may be named in a class action lawsuit where you don't have ultimate control of how and when you exit. And these products are useful, but your responses do interest me. You know, when you sit down at the start of a piece of litigation or a threat, excuse me. My question was going to be whether you consider these products, but evidently.
No, absolutely. And to be honest, no, I haven't, to be frank. And it's something that I actually found really interesting by being on this panel. Always a good learning experience. And but I think where we're sort of coming from would also be that, you know, when you have these sort of hedging options available to you, and it kind of increases the scope of exit options that you have as well, because otherwise simply the monetary amount that needs to be put down limits what you can and can't do when you're looking for an exit. So very interesting to hear about them. However, I have to be honest, I've had no experience with them, and I haven't heard of, I've heard of the products being available, but I haven't heard of them being used outside of a few places in the UK prior to this.
The whole we've all mentioned class actions a few times actually, and there's good reason for that, because there's absolutely no doubt that they are on the increase in many jurisdictions, and the whole process of managing, as on a defendant corporate side, managing or deciding how to manage an emerging class action it can be a really challenging area. Obviously, there are different scales of class action. I have to say, most of the ones we see, and we do actually advise corporates on defending them as well as occasionally bringing them ourselves, but on average, they last between 2 and 4 years, which for a corporate to be on the receiving end of one of those is rather unhelpful, to put it mildly. But certainly in the UK jurisdiction and beyond, actually, they are normally funded. So there's normally a third-party funder behind them, which of course increases the stakes, financial stakes. So I think if there's one area where early strategic risk management of a situation is important, it really is in group actions, because it can make an enormous difference in terms of the direction that one goes. So we've talked about the risk management, we've talked about the funding and the financial side of it. I mentioned at the outset, in terms of some of the trends, the increase in arbitration, international deployment of arbitration. And Beatrice, I'm not sure whether you have a great deal of experience in terms of arbitration and the different options open, and if you do, whether that is featuring more in the sort of early stage contract drafting, dispute resolution clause stage of the business. Is that something you're focusing more on?
Well, it's actually both. I mean, we're focusing to prevent it right from the beginning, from the contract drafting onwards, to have the arbitration clauses in, etc. However, I mean, when it comes to it, I mean, as I said before, the ADR is for us the key in the end. You know, we solved so many cases right from the beginning, but there's a different aspect what people sometimes don't think about. You know, the business always think, oh, we should go for litigation here, we should go to court. But what they underestimate with ADR is that they can find a solution outside the public domain. This is something that is so valuable to protect the reputation of a business. You know, sometimes businesses just want to go ahead with it, just sue the person, etc. But they're not thinking about the power, what comes with it, the reputational damage that is monetary, much bigger, and takes much longer to recover than actually a settlement, which might be very expensive on the first point, and you think, oh God, you're paying that lump sum just to get the issue solved. But there you have the option to actually have confidentiality clauses in place which stop the case basically forever and close the book. You know, what you don't have when you go to court. It goes on for years, it drags along, it is in social media, it's everywhere. That's a huge disadvantage of the digitalization these days. So therefore, I mean, this is something that should be always considered here. When you do your risk evaluation.
And certainly in our experience, you know, if anything, corporates could spend even more time, you know, thinking about the dispute resolution mechanisms they have, the tiered dispute resolution provisions in the contract, so that one is building in layers of of ADR, mediation, etc., before getting anywhere near a formal process, and then and then thinking about the sort of things you've just been talking about, Beatrice, in terms of, okay, well, we want confidentiality, therefore we want to go down the arbitration route. We like the idea of an arbitration body that can also offer mediation services as well, which often they do. So we like the idea of being able to avoid cross-border enforcement difficulties in many cases. So there are all sorts of reasons. I mean, arbitration isn't necessarily cheaper, doesn't necessarily cost less than court proceedings in many situations, but it certainly does have advantages.
And it's faster. That's one big thing. It is normally faster than so.
Yeah.
And you want things to be resolved. You don't want them dragging along. That's not an advantage for any business.
Yeah, absolutely.
Just to interject here, I mean, it's sort of, I wasn't expecting to have an opinion on this or a comment, but we actually own the International Arbitration Centre on Fleet Street, and so over the last 2 years, I've been in there a lot with various clients, and I think James's point there is absolutely right. It's not hugely cheaper. I mean, it's still going to cost you a lot, but usually what happens is when we're talking to clients is that both sides see the reputational risk as being greater of having this in public domain or dragging out, and it will either, as Nikhil said, it might stop them from exiting somewhere, or it might actually stop investments from another company. So there's a huge advantage to doing that, and we're seeing more and more companies coming in with that sort of attitude, and more writing those provisions into many of more of the contracts.
Yeah, and the whole piece regarding visibility of litigation is more relevant than it ever was, and part of the reason for that is there are now, because of technology, there are a number of companies whose business it is to collate information about cases that have been issued in the courts, whether it's London or elsewhere, and to publish that information, which is very often very valuable information, because it's not just who's suing who, it's also gathering data and aggregating data around certain decisions made by various judges, number of cases they've been appealed on, success rate of attorneys, success rate of barristers. That is all very valuable data, but it's also very public. So, gone are the days when a corporate can hope that it won't be noticed that it's just been on the receiving end of a large piece of litigation, for example. Whereas arbitration, as we've said, is a lot more private. So, court litigation has advantages that, this isn't all pro arbitration, but I think again it comes back to the point that one needs to address minds to a very early stage, contract drafting stage, which procedure is going to suit the business better, and for what reasons in certain kinds of disputes. Because of course, arbitration may be suitable for a certain type of dispute, whether it's energy or construction or insurance, but it may not be so well suited to another kind of litigation. But it's all about addressing one's mind to what is the best route for the business. Okay, David, how are we doing for time and questions?
We have about 15 minutes left. So I would encourage everyone to, if people are out there and want questions, please do send them in. I've got one question that has come in earlier, which I think is for Nick much more. It's on the insurance side of things. It says, what kind of rates are clients paying? Obviously, people want to know how much it's going to cost them. So maybe you can address that one.
Absolutely. So, I mean, generally speaking, it is our job to secure the best rates possible for our clients. But on these products that I mentioned earlier, that we're normally looking at single figure digit premiums. So between sort of 5 and 10% of the overall of the policy that's purchased. I mean, and that's not an insignificant cost, of course, especially in the context of some policies we place where there is significant capacity in the market to take big litigation risk.
Okay, and also there's another question that says, what is the global capacity for risk currently? I think that's also something that's on people's minds at the moment?
Sure. I think probably out there for any one litigation risk, there is market capacity for about $750 to $1 billion of capacity for any one litigation risk, which is a serious chunk of change, as they say.
Okay, good. And this is for the in-house. Our in-house is there. Oh, here we got. I'll come back to that one in a second. How often do you develop and revise your strategies from a reporting perspective? Perhaps we'll go to Nikhil first.
Thanks, Dave. So I think in terms of our strategies, we tend to rely really closely on external counsel because, as I mentioned, I mean, when you're operating in about 90-odd countries, your global policies really do need to be localized. And it's the same thing for your legal strategy, at least as far as I'm concerned. The reason for this is that they tend to have a better knowledge of the working system of the courts when you can't get it into ADR. And when you do get it into ADR, assuming it's local and not an international dispute resolution forum, what tends to happen is that there's usually a set number of people that rotate as arbitrators or mediators through these systems, right? And just by virtue of the sheer number of people that they interact with, they tend to have a good knowledge of what they're kind of looking for. So I do have to admit, I rely quite heavily on external counsel in order to be able to be sure that the strategy that we've put in place is the best one. In terms of how often we update it, we do almost a quarterly review with all of our counsels on the litigations that we have to make sure that what we're saying is relevant, that they're getting the information that they need from us, and of course, to make sure that we can feed into Finance's quarterly report before it goes out.
Okay, thank you. Questions come in. How do in-house counsel choose mediators or arbitrators? Is it independently or through an external law firm? I might have a vested interest here, so answer very, very wisely and carefully.
Well, obviously we use the Legal 500, right? I mean, we just Googled the name. But I have to also admit that there's a certain amount of, you tend to kind of work with firms in one company, and then you carry them over with you through the course of your career. And what I found is those kind of relationships work the best, simply because they know your system of working, you know theirs, and you tend to you avoid the initial hassles of, sort of negotiating rates and things like that, because both parties know each other. But I don't know, maybe Beatrice has something else to add.
I totally agree. I mean, I have to say, I was in the direct selling industry before, right at the start of my legal career. I moved out of it, I came back, and I could use the same contacts as of before. And that was brilliant because they knew our business, they understood the needs, they understood what needs to be done here in each country. So, and we enhanced this network. I mean, we review our strategy once a year, but mainly this is checking our contacts are still in place. Also making sure we always have the same clearly we work with, and if we do, it's on a long-term basis. We have retainers in place with external law firms just to make sure we don't slip into some kind of conflict of interest issue, which can easily happen as we are a niche market. The direct selling world is fairly small. So, and also what we do, we keep in very close touch with the chambers of commerce in each region, which is very valuable for us and turned out to be very helpful also with the recommendation of local firms, etc., or even support where you need it. May it be arbitration, may it be something else you need in terms of customs, etc., where you need support from their side. These are the contacts that always remain, and this is what I can say is the most valuable here, coming always back to the stakeholder management, because that's the key of your own success in the end.
Thank you. It's interesting, actually, the questions are coming in about funding, which is intriguing. So one has asked is the use of litigation funding on the rise in international arbitration?
Yeah, I can say that.
Who would like to take that one?
So the short answer is yes, it is. The statistics show that it is being used more and more, partly because there is so much capital out there to be invested by funders into litigation, partly because it's becoming better value for money, frankly, the funding, and also partly because there is more scope within arbitration and under the arbitration rules to recover the costs of the funding. So for the funding costs can be significant because the funders are risking their capital in many cases. So there is more scope. It isn't always possible to recover the funding cost, but it sometimes is. Whereas in many jurisdictions, including the UK, in the courts, it isn't usually possible to recover success fees, for example, for a funder. So yes, is the short answer to that one.
Okay, and one that's come in as well is it's again on funding. It's talking about the in-house side of funding, which from my experience talking to many general counsel, funding just hasn't really hit in-house directly. It tends to be aimed more directly at the law firms looking for opportunities. And what the question has asked is, most people believe that general counsel, in-house counsel, litigation counsel, etc., they're more concerned with certainty of finance rather than not going for litigation. Or certainty of budgets and how much it's going to cost, and being able to control things. Do you think that in your experience is that right, or is it really just a case of we really don't want to litigate very often, and you can offer us money left, right, and centre, and give us this wonderful portfolio of cases you're going to fight, but we just don't want to go. We just don't want to get involved in it.
Well, I have to say, I think it's mostly the first, right? I mean, you don't really want to litigate as a corporate. It does nothing for your reputation to show that you're involved in litigation, right? It's not a question of all publicity is good publicity. And second, I have to say, it's also a really difficult sell upwards. When you go to your board and you say you want to litigate a particular issue, the first question they ask is, what are the legal fees? And is it worth how much do we intend on recovering against that? It needs to be and that's kind of the certainty argument that I think you're referring to. For me, it's less about the budget. Your litigation budget is typically flexible through the year. It doesn't come out of your standard legal budget that you have, for document management services and contract negotiations, because you can never really tell. One year you may get nothing, the next year you may get 5 of them, right? It's not something that stays standard. So for me, it's definitely something that falls into the one-off category rather than the recurring budget sort of category. So the sell is really that for this one-off budget that you create this year, what are the benefits that you're going to see when weighed against not only the cost of the litigation, but also the potential bad press for at least the first 2 or 3 months, saying that this company is suing XYZ. And at least as far as I've seen, it needs to be really heavily weighed on the benefit side in order for us to say yes to it. So less a matter of funding. I think once you've made that decision, then the funding can always be found in the bigger companies at least.
I've got a question, if I may, Beatrice, I pose this one to you, and it's whether you feel that within the business or from external lawyers, you're helped in terms of doing cost-benefit analysis and outcome scenario planning on a financial level on disputes, because I think when we compare the legal profession to, for example, the financial world, we are quite unsophisticated in many cases in terms of doing those sorts of cost-benefit analysis and financial profiling. Do you see that as well? And would that sort of thing help you more as a business to talk to the business in a clear way about financial planning in disputes?
Yeah, sure. I mean, we're all lawyers for a reason. If we wanted to study mathematics, we would have done it. But that is clear. So no, I mean, that would clearly help. I mean, we're all not the experts here on financial impact, what it actually does. I mean, it starts sometimes with calculating the damages. I mean, we all know that it is not straightforward, You have to look really deeply into the business. You need to understand the figures. You need to see what the turnover was last year. You need to compare the numbers. You would need to be able to actually set your case here. And therefore, you need normally the help of the financial department. So, but having support here, that would clearly be something of huge value. So we can only do our bit as much as possible. And risk evaluation.
And that does align with something that came out of a survey we did in recent months of dozens of corporate in-house lawyers who were confirming what we suspected, which is increasing demand for more advisory dispute advisory services from external lawyers. So less sort of, well, let's wait until it's a full-blown dispute, then get the lawyers in. More, let's sort of in bite-sized chunks get the external lawyers in to give advisory work to help us steer on the direction. And so that, you know, that does form part of that. What you were describing came out of the survey as well, actually, in terms of more design, not only for the advisory services, but also for more sophisticated help on the cost benefit analysis. Even though we're lawyers, a bit more of that.
Actually, if I can just quickly jump in here, I think it's not just the cost benefit analysis, right? I mean, both with large firms and smaller ones, what we've experienced, and it's ironic that you brought this up just now because I just filled in a couple of those surveys for some firms as well. And one of my key pieces of feedback was that not all firms have the same level of customer service. And so, for example, if you go to Amazon, to the website, I'm sorry, I tend to be overusing them as an example today, but that's okay. Right? You have a support line. You have everything you need in order to convince you that this is the product that you need to buy. Or Apple, let's use Apple instead, right? I mean, when you go to the Apple store, they will do everything possible to convince you to walk out with a cell phone, a laptop, or whatever it may be. With law firms, very often, like, for example, you'll find that you'll send them an email saying, can you give me an idea of what this will cost to litigate? And they'll come back to you saying, no, I mean, you need to tell me how many hours, how many emails do you plan to send me over the next 3 years? And then I'll tell you what it will cost me, right? And obviously, I get the difficulties in being able to do so, but both sides need to put some risk on the table, right? If you're going to go to your board and say, look, this isn't going to cost more than Y, then your law firm needs to say, okay, look, we'll work with you to get to that kind of number. And that's why I feel like relationships are important. Yeah,
no, it's a really good point. And that whole, the whole area of the external lawyers putting in some risk on the table is, some firms are willing to do it and others are not. And it needs to be done in a structured way. But as you say, that can only really happen where there's a relationship, good sort of client lawyer relationship. There's trust there, it's give and take, and sometimes it will work for the lawyers and sometimes it won't. But that's very interesting to hear that.
I mean, the good news is there's now increasing data available to both in-house and to law firms in order to assess some of these risks, to look at past precedent in a much smarter way and a much quicker way, so you can get that information very, very quickly. So I think most people have some of that data. It is a case of collaborating properly between the two, between the client and external counsel. We are pretty much just about out of our time. I think it's been a fascinating discussion. I think the one thing that people probably should take away from this is get the lawyers involved early, because they kind of know what they're doing. And also it's much easier to fix a problem at the start rather than come in at the end, and usually quite a lot cheaper as well. And always that classic thing that we constantly talk about, communicate, because communication and talking to people is the best way of getting this done. So I've just literally got a few seconds to say a massive thank you to our panelists, to Nick, who is sitting there with Aon colours all around him, Beatrice with the best view of Germany behind her, and Nikhil with his amazing dog who interrupted us in our prep session. And finally, a big thank you to James for chairing this session. We will be emailing you out information about how to look at this recording later. And obviously, I'd encourage you to contact everybody on LinkedIn, and if you each other, but also to ensure that if you've got questions for Freeths, do give James a call. With that, thank you for joining us today, and we will all say goodbye. Thank you.
Goodbye. Thank you very much.